Hello, Eric Smith here with model-based graphical law, and here's a multiple choice MBE style question. It says, newly hired ski gondola operator Bob averred that he had operated ski gondolas for years. In fact, he barely knew how to make the gondola move and neglected to read the operations manual. First customer Nina was surprised when the gondola started and stopped several times. After getting off the gondola, Nina felt distressed and vomited through the night. Is Bob liable to Nina? And we have 4 choices. What we may look at here first is negligent infliction of emotional distress, because of the fact that the fact pattern mentions that Bob neglected to read the operations manual. So if we look at negligent infliction of emotional distress, we will probably find these elements. Option A says, yes, Bob is liable to Nina because Bob breached his duty to properly operate the gondola. So if we look at negligent infliction of emotional distress, we see that in fact the defendant needs to have breached a duty and therefore caused immediate physical impact and injury to the plaintiff. Now, this may seem a little strange here that the nominal tort is negligent infliction of emotional distress, and yet I have renamed it here negligent infliction of immediate physical distress, and I put those words in bold. The reason why I have altered the words here is because it seems that the usual name, negligent infliction of emotional distress, is a misnomer. It simply misnames the tort, and this new name accurately states the elements necessary to be found in what is usually called negligent infliction of emotional distress. The elements really lead to this altered name, negligent infliction of immediate physical distress. And the elements are shown here in that physical impact and injury is necessary. Immediate physical injury is necessary, and it says here emotional distress can be additional to the physical injury. Okay, but we do need immediate physical impact and injury. And these are the elements. Also, of course, the person who was affected needs to have been in the zone of danger. So if we look at the options, option A, yes, Bob breached his duty to properly operate the gondola. That is true, but that is only one element of the tort. Option B says, yes, because Bob caused the distress of Nina. Well, that is true. Bob did cause Nina distress. However, the necessary element here is physical impact and injury, immediate physical impact and injury. In fact, Nina suffered her distress only after she got off the ride, and then subsequently vomited also. And it could be argued whether the vomiting is a physical injury, but it was not an immediate physical injury. The third option also talks about an element of the tort. Yes, Bob created a zone of danger around Nina. That is true, but that is simply one of the necessary elements of the tort. Option D says no, Bob is not liable to Nina because Bob did not immediately physically injure Nina. So option D is correct because this one highlights the element of the tort that is not present, and the one that will ensure that Bob will not be found liable for negligent infliction of emotional distress, which is better called negligent infliction of immediate physical distress. Now we can change the theory and ask whether Bob is liable to Nina under the theory of intentional infliction of emotional distress. And notice here that I have altered the name the usual name of the tort to include recklessness. I think this better represents the necessary elements, or the way in which the tort can be proven in its elements: intentional or reckless infliction of emotional distress. So this is an intentional tort, and we can check and see whether Bob is guilty of this tort. Now, here we have Bob certainly had intent to act in which the way he did, and his act of operating a gondola, safety critical equipment, in a way, we could say that his way of operating the gondola was outrageous, because he knew that he did not know how to properly operate the safety critical equipment, and he certainly intended to operate the gondola in this outrageous way. Those elements can probably be found, and Bob's actions caused emotional distress to the plaintiff, Nina. So this particular tort requires emotional distress. However, the element to be emphasized is that damages are required. So the plaintiff, Nina, needs to have suffered damages. Those damages can probably be shown by her vomiting and subsequent possible physical harms that she suffered because of her emotional distress. So it seems that Bob can be found liable of intentional infliction of emotional distress.